From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Two big tech cases at the Supreme Court as the justices consider a challenge to a Texas law mandating that porn websites verify the ages of their users. Meantime, the political world awaits a ruling on the TikTok social media app, with only days to go until the law says it must be divested from Chinese ownership or else banned from U.S. app stores. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Alicia Finley and Kim Strassel. On Wednesday, the argument at the Supreme Court will be in a case called Free Speech Coalition versus Paxton. It's a challenge to a 2023 law on age verification passed by the state of Texas, though several other states have also moved similar provisions. The statute in Texas says that websites whose content is at least one-third, quote, sexual material harmful to minors, unquote, must begin deploying reasonable age verification methods. The challengers are arguing that this ends up putting too big of a burden on the First Amendment rights of adults, saying that it causes them to incur severe privacy and security risks in order to access constitutionally protected speech. Alicia, what do you make of this case? Some of the argument seems to come down on what exactly the level of scrutiny is that the justices think should apply to this claim.
A lot of states are passing these kinds of laws in part because it's very easy for minors to access porn nowadays on the web and especially on their mobile phones. There are ways that parents can actually help content filtering, screen out porn. These aren't perfect, but this actually gets to the rubber. What the groups representing the adult porn sites argue is that this law burdens the adult right to speech rights and their rights to view porn, and the porn is protected speech, and that's actually very much debatable. But they say in trying to protect children, they are burdening the adult rights, and this is not a content-neutral law, and therefore it has to meet higher scrutiny, and therefore that it has to be the least restrictive means necessary to protect children. They argue, well, this law that requires an age verification is not the least restrictive means that they could instead just require or educate the public about these content filtering methods that are available to parents if they so choose.
But one place to start, Kim, on this legal question, at least in my mind, is that if states are allowed to regulate something offline, I have a hard time seeing how they can't also regulate that same thing online. So there's all sorts of products in brick and mortar stores that require an ID check, cigarettes, beer and wine, obvious examples, not the only ones. I've never bought firearm ammunition on the internet, but apparently it's available. One of the online storefronts I was looking at says this: if your shipping address is in Connecticut, Illinois, New York State, New Jersey, or Rhode Island, we will require the documentation that those states require our office to collect, unquote. And so on this legal question, if the state can mandate an ID check at the adult video store, I have a hard time seeing how the existence of a new technology called the internet can totally moot the state's interest in protecting minors.
Well, it absolutely is true. And no less than the Supreme Court has said that states have an interest in regulating different aspects when it comes to questions of moral behavior, but also even when it in some ways impedes on free speech. We know this from the porn question. There's a 1968 case in which the Supreme Court upheld a conviction of a stationer who sold some, as they called it at the time, girly magazines to a young man who was 16 when the age of the law said that you had to be 17 years old. So you can have these in place. I do think that there are some differences, though. I mean, and that is what makes the online world so very complicated. Going in and showing an ID to a stationer does not necessarily put you up against the same risks as putting your ID and your card information online, where it is potentially at risk of being stolen or hacked or misused. Now, the competing argument against that is that there are a lot of things online that the porn industry is not averse to saying you must provide your card, in particular if they would like you to pay for some of their content, for instance, and some users of their material are happy to do that. This is simply one of those really complex issues where the existence of online websites and outlets does add a layer of complexity that you didn't necessarily have in brick and mortar or face-to-face transactions. That is not to say that there isn't still a very good argument for why this is not overly burdensome. There certainly is an argument that this is something that legislators and Americans are very almost unanimous on wanting in some way. But that is a different question than the pure up one of free speech.
Hang tight. We'll be right back. Welcome back. One of the arguments from the state of Texas here is that this kind of age verification may not have been technically feasible in the early days of the internet, but it is becoming more commonplace. It says that millions of customers who use online fantasy sports betting applications under state or federal laws have to verify their ages. The Texas argues that sometimes those checks can be done via third-party apps where you validate your ID or your credit card, and then the app sends the signal to the website or the service that this person has proven they are 18, but all of the user's personal information is kept private. But Alicia, one of the frustrating things about this and some of the other recent tech cases in the federal courts, and particularly the Supreme Court, is that the state passes a law to regulate some kind of online behavior, and the law is challenged by some group on its face before it has been enforced. And what you end up is a situation where there is a lot of speculation in the briefs about how these sorts of things are supposed to work out in real life. And this is another example. There's all sorts of disagreement about which websites the Texas law would apply to, whether it would apply to sites that are mainly core political speech, if some of their speech is also sexually suggestive content, or if those sites could segregate the sexual content in a certain category and then the rest of their material would not have to be age gated. In previous cases, the Supreme Court recently in NetChoice, for example, said essentially, we're going to send this back down for the lower courts to figure out how this would apply in specific scenarios before we really try to grapple with the core constitutional concerns.
Right. So you're alluding to the case that was just decided at the Supreme Court last term, and these involved social media laws in Texas and Florida. Now, the Supreme Court almost, or a majority of the court held in dicta that it thought that the Texas law, social media law, and recall that these laws were intended to prevent or limit the extent to which the platforms could discriminate against political speech that they did not like. So in Florida's case, would have required companies or platforms not to shadow ban politicians in the states or anyone running for political office. And there was some question about, well, exactly the extent to which websites were covered by the law. Same thing in Texas, which had utilized a different means to attack the same, what it viewed as the same problem, was probably a little more sweeping in its scope. And there was concerns, well, could they actually be read to apply to like Uber, some other, Florida explicitly exempted Disney, but like other online streaming sites? And the Supreme Court said, well, actually, we need to throw this back down to the lower court because you've made a facial challenge to the law, but we can't be definitive, and we don't really know if all these applications of the law are actually unconstitutional, that there may be actually some, as applied to certain websites, that are unconstitutional and violate the First Amendment rights of these platforms. But, we really need to get a fuller briefing on these issues and how they apply to particular plaintiffs. And I would expect that you might actually see a similar outcome here, that the Supreme Court might toss it back down.
Kim, you mentioned the strong support for these kinds of bills. Texas says that its law in the state House and Senate combined. The vote on this age verification bill was 164 yes and 1 no. And interestingly, several other states that have pursued similar provisions that are not at issue specifically before the Supreme Court Court, but would probably fall under any precedent that the justices make in this case. There's one in Louisiana. The vote on that one, according to one article I read, was 130 yes to 1 no. Virginia, 134 yes to 2 no. A couple of bills passed unanimously, Utah and Arkansas. Part of what I think is interesting about that is there are options, content filtering, device level filtering that are available to people. But this looks to me like a pretty strong signal that parents in the U.S. are not satisfied with those options and are looking for something else to solve this problem of widespread access of this material to anybody, including minors, with a smartphone.
I was just going to say that despite everybody talking about, well, just go get your kid a filter. I hear this all the time as a parent of 3 children. It's just, just go enable their smartphones and iPads with a few things and you'll be fine. And of course, any parent will tell you the tech for that is not very good and it's porous. And by the way, it isn't just a question of pornography. We've had a lot of reporting and stories about other kind of very disturbing material that in particular young women can see. There's a lot of worries that some of this and the online usage of what children are being exposed to online is really playing into their mental health. This has grown into an enormous worry for parents. And here's, I think, one of the problems, too, that you face when you hear an argument, or at least when parents hear an argument from a group like the Free Speech Coalition, which is challenging this Texas law, which is they tend to have a double standard when it comes to technology. They like to say, well, on the one hand, they would suggest that all you really need is a public education campaign and parents should just go out and get some of these filters, and tech is invincible in that regard. It'll solve your problems. At the same time, they turn around and say, well, the tech isn't good enough to actually guarantee anybody's security or identity online. Well, which is it? You can't have it both ways. I have always found that sometimes necessity is the mother of invention. And while there isn't much of a necessity for any groups out there or need that they feel to come up with better tech to help parents, there probably is a bit of a pressing need, especially if this court case went against them, for certain industries out there to work closely with the tech industry to come up with better technology to shield people's privacy and to make sure their credit cards were secure online. So I think one of the hard parts is that the justices also get faced with this question, like what tech is possible and which tech is better? And those are just really hard questions for judges to sort out.